welcome everybody. I'm John Khosravi. Thank you for joining us. JQK Law Firm's weekly Q&A session, taking your questions for general education purposes. Every Wednesday, 5 p.m. Pacific time, we're here. It's a half-hour show. We're coming in 10 minutes early. We do that a lot just to get more questions in. But with that, let's get the show started. There's a lot of immigration changes in the news right now in late July. I want to share, they're all over the place, but most of them are pretty good. So the first one I want to start with is the fact that it's a mixed bag one, that employment authorization cards, work permits, for those who file for adjustment of status, this is if you're filing for a green card from within the United States, you file for adjustment of status. With that, you could file Form I-765 for an employment authorization document, EAD for short, or work permit as we all call it. They're going to give those for a 2-year period of time instead of 1 year as they're doing. So it sounds kind of good. Okay, they give you a full 2 year, but the backhanded part of it is the reason why they give 2 years is because it seems they're going to be expecting a lot of delays in adjudicating and deciding these green card cases. So they're giving you 2 years of work permit time ahead of time so that you don't have to refile, create more work for them. You know, it's a mixed bag. It seems good. On the positive side, the massive delays and amount of work coming into USCIS has caused them to start thinking things a little better. One example is that for student visa people applying for student visa status in the United States. So if you're in the United States, for example, on a tourist visa, a B1, or more likely a B2 tourist visa, usually get 6 months on that. If you come in and then change your mind and decide to actually stay and go to school, what you had to do previously was file a Form I-539 and request a change of status to student status. But also you have to file another Form I-539, pay additional fee, and request an extension of your tourist visa at the same time. So, tourist visa status at the same time. Now, it's very confusing, and a lot of people who would file these cases on their own weren't aware that you have to submit 2 applications for some reason. One to extend the tourist status, one to change from a tourist status to a student visa status. Didn't make much sense. It was unclear in the instructions. Many people got horribly hit by improperly filing these. But hey, that's the situation. They finally said you don't need to file these bridge B2s anymore. You could file the F1. Now, the solution they had still has issues and inconsistencies that we're trying to word out, but I just want to give you a heads up that that's one of the positive cases. On the negative side, going from positive to negative, is deferred action for child arrivals. This is DACA, the Dreamers. These are people who came to the United States as young children, and President Obama started a program where they could, at least stay here without threat of deportation removal if they've had, a proper situation. If they've had no criminal history and anything like that, they'll get a work permit. Well, a judge in Texas said, no, this program is illegal and they won't allow it. So the consequence of that is they'll let the people who had DACA continue it, but no new filings are possible. And so the people who have submitted it since it went away under Trump, it came back. Those new ones that started initially when they came back, they will not be accepted. The biometrics appointments are being canceled. In those cases, are going to be sent back. So that's a negative news. But if you had DACA and you want to do advanced parole for it, those are still going on. In the news, it was reported that these cases, because so many people filed for DACA in this few months that they had, USCIS got overwhelmed, and the processing times for this got horribly delayed and out of control. And so maybe now that they're going to stop adjudicating those, they'll create more time to adjudicate the advanced parole cases. People who were here on DACA needed to travel for emergency purposes. Those are taking 3 to 6 months, 6 months easy. Hopefully, those will become a little faster. And so there's other stuff too, keeping the bad news alive. The Department of State, these are the people who handle the embassy system. They have a website that they update now every month that says how many cases are in the backlog to getting an embassy interview. Now, typically in 2019, this time before the pandemic started, there'll be 50 or 60,000 cases waiting to have an embassy appointment in the 100 embassies that are in the world. But right now, be prepared, trigger warning, 500,000 plus cases in backlog to have their embassy appointments. It's wild. So that's the situation we're dealing with. They're telling us that's the situation. And so, that's what we have to deal with right now. So if you are outside the United States, expect continued delays on getting the immigrant visa interview, even a regular interview for a non-immigrant visa, tourist visa, and stuff like that. Those are pretty much shut down for a lot of places. So that's the news with regards to immigration, late July, or 3 quarters in of 2021. So there's a lot in this immigration situation we're going through. I'm getting a lot of questions coming in. in particular, about DACA. And we don't know what's going to happen with deferred action for child arrivals. There are groups of people who came here as kids. They got special permission to stay here. The program is semi-blocked. We got to see what Congress does, what the new president does about it. The courts are going one way. It's all up in the air. It leads to a lot of stress and tension for the people who and their families who are in this program. But if you have DACA already and you have a chance to get a green card, you definitely should look into it. Some people, have lawful entry. I have people that could get a green card years ago and they haven't. They're married to U.S. citizens, for example. Definitely, if you have DACA, talk with some lawyers and get an idea of what's going on with the whole thing and what options you have. You don't want to be left in the dark. You want to have some good options, or at least if you don't have options, you want to have a qualified person explaining it to you so you know exactly what's going on so you can make a proper decision. So going back to what I was talking about, the EADs, employment authorization documents, they're going to be extending for adjustment of status. We're still seeing delays just getting the employment authorization document in the first place. We are getting faster at getting receipts, much faster, and somewhat faster at getting the biometrics appointments, which were taking forever long. So that's kind of getting things faster to get it. But employment authorization documents, right now I have cases 9 or 10 months, still no EAD. So it's a very, very peculiar thing. There's a lot going on in these marriage cases. I have a case right now where the couple filed on their own and they went to the interview and they were not prepared for the questions being asked, and didn't answer well. And they got a notice of intent to deny because the answers were inconsistent. And when we went over it, I saw that they had good answers and responses, but they're overwhelmed the interview, couldn't handle it, and they give like mixed answers where the officer didn't understand. And now they want to deny the case, which has catastrophic results. So now we're trying to fight it. We're going to work on building the case. They didn't submit good evidence. They submitted insufficient evidence, inconsistent evidence. They didn't prep the case well. They didn't prep their lives well for what's going on. And so it's just sad to see. The idea is hopefully, this case is easy enough to file on your own, and most people probably do file on their own. But, I see the disaster stories, so that's why I recommend everyone to study up, take it very seriously. Don't say this thing like, oh, no, we're a real couple. We have nothing to worry about. You're dealing with the government. You're dealing with a blunt instrument. You never know who the person is you're dealing with. So even if you don't hire an attorney, take it very seriously. This is a big deal in your life. The consequences are dire. So you want to go in with your eyes open, really prepared. Don't just say, oh, I'm an American, if the petitioner, I have no arrest history, I have nothing to be afraid of. You're dealing with the government. You never know what kind of errors they're going to make and misunderstandings are going to be. You want to have your best foot forward and be really prepared. So don't go at it with that kind of mindset. It's going to create a lot of problems for you all over the place. And I see it every day. People call me every day with these kind of problems. Can you explain about the E2 visa? Sure, E2 visa is a wonderful visa. I wish there was more of it. But essentially, it says this: if the United States has an agreement with the foreign country, and you're a person from that foreign country with a passport of that country, you could come and start a business in the United States. There's no minimum investment. The investment amount just has to be enough to make a case viable, to make sure it's realistic. It's not like you're starting a factory, a car factory with $10,000. That wouldn't make sense. The money invested has to make sense with the work that's being done and the company that's being created, or sometimes you bring employees from the home country as well. And so the one issue is you have to invest the money first, for the most part, a majority of it at least, to and put it at risk, and then file for the visa. If the visa is denied, you may lose out on that money. So that's a dangerous aspect of it. But it's a great program. You definitely need to consult an immigration attorney to see what's going on, so if it's appropriate or not. But it's an investor program. The first thing you do in this kind of case for an E2 is you see if the country you have a passport from, and some people have multiple passports, is this country on the E2 treaty list with the United States? Is there a treaty for this visa category? If there is, you can take it forward. Most of the big countries in the world, India, China, Russia, Brazil, they do not have the E2 treaty with the United States, so that is going to be problematic. We can't use it. But we have a lot of Brazilians, for example, who also have Italian citizenship, Spanish citizenship, French citizenship. If they get the passport from that country and they apply for that, it is possible to the E2. There's a lot of nuances we can't get into here as case specific. But other than that, the main thing to know is, yeah, it's possible. Just gotta look into it, talk with an immigration attorney, and see how they can help you on that. Oluwartimi, one of our regulars, says, good evening, sir. I hope you and your family well. God bless you, Oluwartimi. Good to talk with you again. And ask, I'm an American citizen. Can I file for my mother-in-law? My wife's mother's in Haiti because my wife has a green card. Will it be faster? Thank you. Well, no, unfortunately. To be able to apply for a parent, you have to be the child. So you could file for your parents if they're overseas, but your wife would need to file for her parents but because she has a green card, she can't apply for her parents. You can't do it as a son-in-law, unfortunately. So you have to wait a little longer. Your wife has to get her citizenship as soon as possible. And what I do in these kind of cases is, for my clients, I have the case prepped ahead of time so that as soon as you get the naturalization certificate, you file that citizenship case. File the green card case for the parent, so you hurry it up. But Haiti's backlog and they're not processing cases. It's going to be a while before this could happen. Sharing and Caring asks, hi sir, how are you? I want to know this month I want to submit the M400, the citizenship case, while my I-751 is pending. That's removal of conditions. That's when you have a green card. That's a 2-year green card. You want to get a 10-year green card because they want to check to see if your marriage is real. So the I-751 is pending. Is it better to submit request letter to adjudicate my I-751 and M400 together? I need your help and service. Well, you can't request anything. What happens is, if you have an I-751 pending and you apply for an N400, they're supposed to put it together. That's what USCIS has done. They put it together and they try to adjudicate it later on. They don't always do that. You don't have any control over the situation. So, just submit your N400 and then see what they do. They should know that you have an I-751 pending. It's really easy for them to look up. They'll see your green card is already expired. So, you just got to do your part, file a case when it's appropriate, and then hope for the best, and hopefully it doesn't take too long. Ulua asks, hello, if I divorce my husband and he has a temporary green card, will that be taken away from him? No, it won't be taken away from him. Your husband, if he has a temporary 2-year conditional green card because your marriage is newer, will need to file a Form I-751 removal of conditions, just as he would if you're still married, and then has to, satisfy USCIS that although the marriage is not together anymore, you're divorced, you are, we're still really a couple. It was not a lie. They'll want evidence, they'll want paperwork, they'll interview him, they'll talk with him. But these cases do get approved unless they just don't believe him or something like that. So it is possible for your husband to keep and maintain their green card, eventually get U.S. citizenship. Gio asks, good evening, please, any updates about Essential Act? The reality is don't even look until they say a law is passed. Don't even bother researching. Don't even bother reading. Don't follow the news. It's all just hype and nonsense. Until a bill is passed and the president signs it, there's 50 immigration bills that come out every year, and 99.9% of them don't go anywhere. So whether it's Essential Act or whatever this kind of stuff is, it's just wasting time. Go enjoy your life. Don't think about it. I know you want to think about it because it's going to help you potentially. But, that time is going to be wasted because they have no control over it and nothing's probably going to happen. So, spend the time with your family, exercising, having a good meal or something like that. Don't waste it thinking on what's going to happen in Congress or Senate or all that kind of stuff. They're a very unreliable organization to even follow. Infinity asks, hi, I've applied for adjustment of status. I came with a B1, B2 visa that will expire in 6 months. So I don't have the rest of your question, but I think I know what you're going to be asking. What happens? You have a green card case pending, and you have a tourist visa that's only 6 months. The green card case is going to take a year probably. What happens in the meantime? Well, they have this thing called an authorized period of stay. Once you're in the United States and you start a green card case, filing Form I-485 for adjustment of status, you are in a period of authorized stay until a decision is made on the case. So you can stay here even though the visa expires. Now, it does not guarantee that you won't be sent to immigration court, but realistically, they made a determination, practically speaking, that what is the point of sending you to immigration court if you have a case pending and you're potentially going to get a green card? Let's see what happens. So they, most likely you just wait until, your interview happens or a green card is issued. And if you're denied, then you may be sent to immigration court. Rarely will they come knock at your door looking for you, although it's done, but very, very, very rarely to a point that it's not something I'm worried about. What typically becomes problematic is while you're waiting for the green card, if you get in a fight, if you drive under the influence of alcohol and this stuff, the police comes in, that's when it becomes problematic. But if you came on a tourist visa and then change your mind, decide to stay and file for adjustment of status, you can stay in the United States until a decision is made. You don't need to maintain status after the I-485 is filed. As long as it's not a frivolous I-485, you filed it properly, there's not other issues. So there's always more we can analyze in the case. But very specifically, do you need to maintain status until a decision is made? No, you just have to have proper status at the time of filing, with some exceptions. For example, if you're married to a U.S. citizen, even if your B1, B2 is expired, you can still file for adjustment of status if you enter lawfully. So there's a lot going on there, but I think I rephrased the question you may have, and I hope that answered it. But thank you for your question, Infinity. Minnie asks, I'm applying for both EB1 and O1. Should my recommend, so EB1 is if you have extraordinary ability in some area and you're applying for a green card, and O1 is similar, but it's for a temporary work visa to work in the United States, but not a green card. And this person, Mindy, is filing for both. Yeah, should my recommendation letter specify which category I'm applying for, or can they just say immigration petition so I can use the same letter for both petitions? The reality is the recommendation letters are about your background and what you do. So they shouldn't even really reference immigration. It has nothing to do with immigration. And the focus should be on who the person it is, how they are qualified to give this recommendation, and secondly, detail how you are qualified specifically to have this commendation. So that's what you should focus on. Now, mind you, I don't file O1s and I stopped doing EB1s. So if you have an immigration attorney, listen to initial individual counsel. But when it comes to a letter, the point of the recommendation letter is to recommend you as a person, not to discuss any immigration matter. The recommender signing it is not in a place to give immigration opinions and stuff like that. It's not what they're trying to do. They're trying to talk about how great and successful you are. I don't handle these kind of cases anymore, but I have a lot of colleagues that do. Just contact my office and I try to connect you with somebody if you want to consult with an immigration attorney about something like that. Peace for All, I think one of our regulars, I've seen the name before. Hello, if a petitioner for a spousal visa doesn't have work, is she required to send an I-864 signed by the joint sponsor together with the I-130 package, or petitioner can send I-130 package without tax return? So when you're doing a marriage case, you have to include an affidavit of support. And so in this case, the U.S. person doesn't have work. Well, the reality is they still have to submit the form I-864 regardless of whether they're financially supported or not and choosing a joint sponsor. Every petitioner has to submit I-864, and if you have a joint sponsor, they have to do it too. Now, with that petitioner I-864, even when they're not working, they have to submit the most recent tax return or have letters explaining why they did or did not file taxes in the previous 3 years, or explain why that was appropriate. So even though they're not financially able to support you based on their current income, they still need to file the form I-864 for an adjustment of status family-based, and they need to submit any tax returns they have. And if they don't, they need to specify why that is, or else the case is going to get an RFE and rejected eventually. Same question. So it's a marriage case. They filed an I-130 package. Will be rejected if it doesn't include income proofs or I-64. I was wondering if that can be sent later. Under Trump's regime, they would be rejected. Under this new regime, under President Biden, they say it won't, but it's always possible. You do not want to send an incomplete application. That's never a good idea, because the reality is there's 1,000 different officers. You never know how each one's going to. I could say it's okay, but if they want to reject it, they can, and then we have to pick up the pieces. So it's inappropriate, and I can't even recommend submitting an incomplete package. So if time allows it, wait and get the full thing in order and do that. And Peace for All says, thank you, you're welcome. God bless you, Peace for All. I wish you the best in your application. Now, one note I want to make, I want to do at the beginning, and I want to make sure it gets out there. We'll make a clip of this. It's for Australians. So the country of Australia, unfortunately, because of COVID, they've restricted the movement of their people. Both leaving Australia has gotten very hard. There's like someone's in prison there right now because you can't leave unless without special permission. But also entering is restricted. And they've gone an extra step and put a ban, a limitation on even their own citizens from returning to the United States. So right now in America, we have thousands of Australians who came here as tourists. They're here. They come on a program called the Visa Waiver, or the ESTA program. And with the ESTA program, they can stay up to 90 days here. And then before 90 days done, they return back home. But a lot of people are getting notified by their airlines that the government, Australia, will not let them return at the intended date, and they're rescheduling their flights past the 90-day mark. So that's terrible, because that's automatically going to force them to violate their stay in the United States to create problems. So in these kind of cases, you have to contact the local CBP port where you're probably exiting. CBP is the Customs and Border Protection, and ask them what is the procedure for extending it for 30 days. And then once the 30 days is done, doing another extension. Some will help you out there. Some will say contact USCIS about this program. But you need to, if you're feeling this happening, as soon as possible, don't do it the last day. Don't do it a week before. Try to at least a month before the expiration, the 90 days are up, to contact first CBP at your local, see if they're willing to do it. And if not, then contact USCIS to request this extension. It's going to be a lot of work, a lot of phone calls, a lot of headache, a lot of paperwork, and it's not clear whether it'll be approved. But you got to do it, because if you overstay, it's going to have consequences later if you don't get the permission. it's a disaster all around, the fact that Australia is doing this. I can't believe it that a country would do this, especially a Western country. But it's what we're dealing with right now. And, it's so much hassle to fix it. But that's the situation to deal with. We saw this at the beginning of the pandemic as well, when people were afraid to fly and they were requesting these extensions. CBP was doing it. Then many of the ports were backing up and saying, no, contact USCIS. So there's a hodgepodge of laws on how this is being done. That's why you have to contact the local port that you're going to be dealing with to see what their procedures are. And if they do it, if not, contact USCIS. You may need an info pass appointment, which are very, very hard to get. It's even hard to get someone on the phone with USCIS. You may be on hold for hours, and they might hang up on you. So it's gonna be a really, it's a ruin your vacation. But that's something to be very careful of if you're Australian. You want to make sure you try to do the paperwork right, and hopefully you do. But I wanted to share that with our viewers. I know we have a lot of Australians, I have a lot of clients that are Australian, so I'm getting the emails and I'm aware of this disastrous situation. Hopefully this guidance will help you try to solve the situation. Your buddy asked, do you know if there's any delays for DACA renewals? Yes, there is. I mean, DACA renewals itself are usually pretty quick, so I wouldn't say there's delays there. What I'm seeing delays is advanced parole getting approved for DACA holders, and so that's taking a little longer. But my DACA renewal cases, I don't do too many. They usually come back in 2 to 3 or 4 months is normal. USCIS got overwhelmed with all the new DACA filings, so maybe there'll be some delays there. The new DACA filings are seriously delayed, but those are stopped because of the new court order. But that's something that's there. Thank you, everybody. God bless, and I'll see you all next week. Bye-bye. I hope you enjoyed this educational video. We have a second channel with much more information as well at JQK Immigration Clips. Please check that out. Also, you'll find our social media site has a lot more videos, images, and information about the U.S. immigration process. Please check those out on the various social media websites.